Appeal number 55, the people of the state of New York versus Otis Boone.
Oops, sorry.
Good afternoon, Counselor.
Good afternoon. May I reserve 2 minutes for rebuttal?
You may.
Layla Hull from Appellate Advocates representing Mr. Boone. Science and common sense shows us that we should educate juries about unreliable
Counsel, what's the rule you would have us impose?
The rule I would have you impose at the very bare minimum is that when a cross-racial identification is undisputed, that the court should give this charge.
So undisputed meaning what?
Undisputed meaning that when counsel, for example, at the charge conference, characterized the two parties and characterized their races, and the people did not dispute that, nor did the court, you should give the rule.
If it was disputed, then what would happen?
I think the Massachusetts rule is actually quite a good one in this regard, because you would still give the rule unless the parties agree that it's not at issue. If that is not the rule that this court would want to adopt, the best rule would be to have the court.
So that means that if the parties disagree whether or not a cross-racial identification is at issue, is a factual determination for the jury?
Yes, Judge. That's precisely what.
What would they need to be able to make that factual determination?
If you look at the underlying scientific studies that were conducted in these cases, oftentimes race was determined mostly based on visible distinctions between the individuals involved. And so
That might not be so accurate. Do you then get back to the people's position that if you really want to do this right, you want to educate jurors, and we want fairness, and we want to avoid wrongful convictions, what you need is an expert to get on the stand to help educate that jury?
No, because this.
Why not?
Because the effect itself is not in dispute. And what you really need here is a jury instruction to alert jurors who are otherwise unaware and uninformed about
But
the
again,
specific
if
factor.
the science, as you argue, shows that it is counterintuitive to what jurors believe, their experience, then how is a one or two sentence or a paragraph of an instruction going to educate them to be able to overcome that during deliberations?
So our position is that jury instructions can at least alert them to the factor, and this jury instruction will give them the necessary information, which is that you should be aware that it's commonly understood that people have difficulty identifying a person of a different race.
How do we get around our decisions in Knight and Whalen, where we said it was a discretionary determination whether to give even the expanded identification charge? How can a mandatory charge for this, which is in a way a further expanded identification charge, how could making it mandatory be consistent with that precedent?
Well, I think there's 2 points to make. One is that because the court gave the expanded identification charge, Whalen and Knight don't necessarily control here. But the other one is Whalen and Knight.
Well, no, I know that we're not talking about the expanded charge here, but we're talking about the concept
Absolutely.
that is discretionary. If that is discretionary, why would not this charge be discretionary?
Certainly. I think there's two other reasons. One of the reasons, the underlying rationale from Wayland and Knight is that, jurors are probably going to understand that lighting and distance and duration, these are sort of common sense factors that a jury would probably think about anyway. But this is not. So this stands in contrast to what was listed in like Daniels and otherwise in the expanded ID charge.
We don't require a charge for things like child abuse, sex abuse accommodation syndrome or rape trauma syndrome, other kinds of, I think, scientific, if you will, principles that are pretty well accepted these days. So why is this different?
Because I think one of the things that we are very concerned about is that the jury needs to be educated about issues that are not that in terms of how they're going to reliably assess critical evidence in a case, and witness identification evidence, which has resulted in juries convicting people wrongly and based on DNA exonerations have been shown to undermine the truth-seeking function of our justice system. We have decades of scientific research that shows a clear consensus across populations and age groups. That's
Is there scientific research at this point that supports that part of the CJI charge that refers to the jury considering the nature and extent of the witness's contacts with persons,
No.
the defendant's race?
No, there isn't, Your Honor. There is actually, this is an important point. There isn't, the scientific consensus is about the effect. There is no consensus about the causes or what could potentially mitigate, which is why we also argue that giving the charge shouldn't be conditional on the defense being required to ask a witness, the degree of their contact. Now, it's certainly relevant under the charge, and the people or the parties in any given case could ask those questions. But it's not, there is no scientific consensus. The people's sources actually support that, noting that there have only ever been mixed results. There are competing theories in contrast to cross-racial contact as well. And that's also one of the reasons why the Massachusetts Supreme Court...
So let's say we agree with you and adopt, you seem to be promoting the Massachusetts rule, rule, the people will know in advance, it's mandatory, unless the parties agree otherwise, and the people want to put on an expert that says exactly this. That exposure of the witness in this case to persons of the defendant's race makes a difference in their ability to remember and discern individuals of a race other than their own. Can they do that, or would that be excluded? Since you say there's no scientific basis for it.
I don't think there's enough science.
Do they have to have a Fry hearing on it?
I think they would need to. They would need to go through the same requirements that any defense attorney would be required to go through.
Except you're saying that the defendant wouldn't have to put on an expert to get this charge.
No.
They're not going through the hoops of the Fry hearing.
Well, because there's no dispute about the cross-racial effect, and that's the purpose of the charge, to alert a jury to the effect.
So would we be overruling Alexander? Can a prosecutor now get up and say this is the same race identification, and you'll hear if I ask for it, this charge, and now, this identification, obviously, you can put more faith in.
Alexander is a bit different. I don't think you'd have to overrule it. Alexander is about summation, and also you have to look at what precisely was wrong with that summation comment. In addition to referencing cross-racial, the fact that it was an interracial ID, the prosecutor characterized it as strong and good. Stranger eyewitness identifications oftentimes are unreliable.
But that's argument. I don't think there's a problem with a prosecutor getting up and making an argument and saying that was a good ID. You saw how strong that ID was. The problem in that case was his saying that this was a same race ID, and it isn't like, everybody knows, and we said, no, you can't do that. It wasn't because he said it was a good identification.
Well, to the extent that you feel necessary to overrule Alexander, that's something the court can do. Our position is that Alexander, it was the prosecutor going a step too far, because the absence of one unreliability factor doesn't transform an otherwise unreliable ID into a strong one.
So you could say one of the factors that you should consider in evaluating this ID is it's a same race ID.
Yeah, and that's very different than what the prosecutor in Alexander did.
But that would be okay now.
Possibly.
Can I ask two questions? First, and then two separate issues. First, you're not asking us at all to address cross-ethnic identification.
No, because it's not implicated in this case, Your Honor.
How about the question of the retroactive application of this rule that you're proposing? Have you given any thought to what you think the effects of that would be?
Okay, so I have to dig back and remember Pepper right now, and I would imagine that the best thing for this court to do is to address that question while it's fully briefed, because if I'm recalling Pepper correctly, and I can do that.
Well, that's good.
I'm trying. Is that part of the
I had to go look it up before I started this case.
I hope I get this right.
In the minority in the courtroom, go ahead. Yeah.
is that one of the factors, and it is one of them, is to what extent does the rule implicate the truth-seeking function of our justice system? And this, as not only
It says, what it says is the heart of a reliable determination of guilt or innocence, and that's the key factor that we have to look at. And it's hard for me to see how identification or misidentification, of course, wouldn't be about a reliable determination of guilt or innocence.
That's precisely why we believe this issue is of such importance and why jury instructions
I
are
accept that.
critical.
What I'm curious about, though, is the
Yeah.
retroactivity and its effect on cases that are already in the system.
Okay, I think that this would.
Well, but your argument is about the point of social science, right?
No, I'm saying that social
sorry,
science
I'm sorry, I
demonstrates
interrupted.
that it implicates the truth-seeking function of our justice system, which is, I
So it will be retroactive to some degree, but only if it's preserved.
I think perhaps, certainly to anything that's on direct appeal, I would encourage it to be applied should this court, I'm not.
That's a separate question, but.
But I do think it's an issue that you probably would want a significant more briefing on because it also is weighed against other factors, if I'm recalling Pepper correctly.
But I thought your argument is driven by what you say is now the consensus in the science.
Yes, which is
And if
why-
the consensus in the science is something we can now realize, how is it retroactive? At what point was it not obvious in the science?
I would absolutely advocate for it to be retroactive.
No,
I
I
just
understand
didn't
you
have
would
an
do that.
opportunity to
I
brief it.
understand you would do that.
I just didn't have an opportunity to brief that.
Would it
issue.
be
All right.
per se error to not give the charge?
I think it would simply be subject to harmless error. I don't think it would be per se error in the sense it would not result in a per se reversal, if I understand your question correctly. But it should be subject to harmless error, as any legal error would be.
Thank you, counsel.
Thank you so much.
Counsel?
Good afternoon. My name is Seth Lieberman. The people share the defendant's goal of enhancing the probability that the innocent will be acquitted and the guilty will be convicted. And so, obviously, if the jury is well informed on all the matters that are relevant to the determination of the case, that will enhance the probability of the innocent being acquitted and the guilty being convicted. Consequently, in the appropriate case, we believe a jury should be informed about the cross-race effect. But the proper way to do that is by means of expert testimony, not a jury charge. Unlike a jury instruction,
We don't require expert testimony to give an instruction on accomplice testimony. Isn't there some similarity here? Because we're saying that you need to look at this testimony closely because there's a tendency, maybe not to be as reliable. And we don't require an expert to come in and say that.
that may be a matter of common sense.
Well,
This is a
but
matter of
isn't that the question here, is whether this has become so accepted that,
among whom?
well,
Among experts, among people who are knowledgeable about the science. The defense and the amici are arguing, and I have no reason to disagree at this point, that people in general are unaware of this phenomenon and do not know how to evaluate it. That usually, under New York law, is the subject of expert testimony, something that's beyond the ken of the jury.
No, that's not true. You charge people on distance, on lighting, on other factual elements. Let me finish the
Yeah.
thought. This would just be one more analytical factor that's being called to their attention. It doesn't necessarily require expert testimony in the same way that you don't require expert testimony to talk about how fast a car is going when there's an automobile accident could affect how serious the impact is.
Your Honor, all those-
Common knowledge.
all those factors, distance, lighting, are common knowledge. That's part of everybody's experience. The defense,
I think what the defense is arguing now is that this is part of everyone's
they're
experience.
not saying that. That's not their argument. If you look at their brief, they're saying that's exactly why they need the instruction, because they're not aware of it.
So if we agree with you, does that mean that in every prosecution where the defendant believes there's a cross-racial identification issue presented, that every time they have to bring in an expert? So how many times before we get to the point that, excuse me, that we've recognized that the science is there, and we don't need to keep having experts to get up and say the science has reached consensus on this point. Not that this witness wasn't able to recognize it, but just this general scientific conclusion.
Yeah, but that's true of all scientific conclusions that are beyond the ken of a jury. The law in New York is that evidence, that's an evidentiary matter that is presented through expert testimony, and the judge is ordinarily not in the role of being an expert witness under the guise of giving an instruction. And this is a complicated phenomenon.
But wouldn't that really go to the type of instruction that you give? Because if you're vouching for the science, then I think you have a good point. But if the instruction, and I believe there's one in the task force report, that is, it may be your experience, or isn't that different than giving an instruction that says this is how it is? You know, you may consider this if it is your experience.
But
So why would you need expert testimony for that?
okay, is it common experience? Is everybody aware of this? They cited statistics saying that over 50% of people were unaware of this, did not know how to
Then
analyze
it won't be their experience if you give that instruction.
Then I don't understand what the jury's supposed to do with it.
Well-
We want to educate jurors in a way that they can come to the right decision.
You make a good point. It's kind of an epistemological problem. It's when do we acquire the knowledge that we acquire to allow us to make these decisions? And in the process of acquiring, when does it become knowledge in the general human community? At one point, everybody thought the world was flat. At some point, it became generally accepted. It's that kind of a question. We appear societally to be at a moment where we're transitioning from this, on this particular point where nobody knew about it, to more people know about it. The question is, though, can a charge be crafted that respects both sides of that transition? I'm not sure the answer to that, but
Your Honor,
go ahead.
juries should be educated about complicated scientific matters, which this is one of them, by experts.
I guess that's the
scientists,
question.
Not
Lem-
by
lem-
a simple.
Let me stop you a second. Is this a complicated scientific matter?
Absolutely.
Really? Tell me why.
For several reasons.
Yeah.
One is the whole issue of contact, okay? There's disagreement among the experts about not the notion that contact plays a role, because obviously it does, but what kinds of contact? Jurors have no clue about that. Or a lot of jurors might not have a clue about that.
But then,
Second-
doesn't that leave you free to present, isn't that my point to your adversary? Doesn't that leave you free to bring up,
No,
put
but-
in an
No,
expert?
but the thing is, you want to give an instruction to the jury that is not misleading, that gives them the tools to be able to make a determination of whether this particular witness had the ability to identify the perpetrator and how the cross-race effect might have affected that ability. You want to give the jury the tools to do that in a well-informed fashion, not with a simplistic, superficial instruction that does not explain to them how to evaluate the cross-race effect in the context of the particular facts of the
But
case.
then don't we do exactly what we don't want to have happen with expert testimony in this particular area, where the general proposition is apparently well understood in the scientific community, but then some of the specifics of it, as you say, what kind of contact and that sort of thing, doesn't that then get us into a battle of the experts and distract from the main trial?
No, not necessarily. But what do you
Isn't it likely it won't, because most defendants, indigent defendants, can't afford the experts?
No,
You've
no.
basically left them in a position where they won't be able to present the evidence that they say is so obviously available, and science has come to this conclusion. Because you want to keep relitigating the science.
Not at all. I don't, the cross-race effect,
All right.
we are saying is an accepted proposition, but you have to be able to understand whether it's in play in the particular case. And as far as whether a defendant can afford it, indigent.
But isn't that true for the eyewitness reliability instruction as a general course anyway?
No, but
That's true
those are
anyway.
common sense propositions, that everybody has that experience.
No, it's counterintuitive too to many jurors, right? To believe that an eyewitness may have made a mistake, that eyewitness testimony is not necessarily reliable. Depends on the circumstances.
That's not counterintuitive. We in our own individual experience all the time know that we are not able to identify certain people at a
And
long
yet,
distance
a
in the dark.
majority of wrongful convictions are based on eyewitness misidentification, where the eyewitness is certain, of course, as they would be,
Well, that's why.
that they chose the right
That's
person.
why we want to educate jurors about it in the proper fashion. Not in a way that's going to lead to misinformed decisions. They should know everything about it. And as far as cost is concerned, for the indigent defendant, the state will pay for it, okay? I don't know how many cases there will be for people who can afford experts that they would need to present the expert, because I don't know whether the cross-race effect would be at play in those particular cases. But we want to do this right, okay? We don't want a simplistic instruction that's going to leave out important information that's going to lead to incorrect decisions. We want the jury to be informed in the best
And
way
what will the
possible.
state do when, even if it's willing to pay for the experts, there's a small, what will the state do when, even though it's willing to pay for the experts, I don't know if that's true, but we'll go with what you say, there's a small pool of experts available for these cases, making it particularly difficult
What-
for a defendant to be able to
What-
present a defense.
there's-
Sounds to me like you're creating a
What's-
constitutional.
What's the evidence for that? You know what they rely on to say that it's a small pool of experts? It's a 2008 American Bar Association report that relied on the statement of one lawyer talking about Los Angeles and rural areas. A jury would not even say that that is proving a paucity of experts. That is a factual matter. This is an extremely important issue. We should not just have a quick fix, which will lead to perhaps unintended consequences. And by the way, looking at the actual language here, what kind of guidance does this language give to a jury? It says some people, doesn't give the jury any indication of how pervasive this phenomenon is, then talks about the nature and extent of contact, but it says nothing about how much contact or what nature will affect.
Let
the
me ask you a
cross-race-
question about this case. Do you think that the trial judge here made the ruling not to decline the charge as a matter of discretion, or do you think that that ruling was made under the belief that without expert testimony it could not be given?
I'm not exactly clear what was in the judge's mind. You can only look at
Well,
the
you can look at,
language.
yes, well, and you can look at the colloquy that
Right.
took place there.
Well, it's not like the defense attorney gave the judge much help. The defense attorney barely made an argument. The judge, I'm not sure what the judge would have said if expert testimony had been given. Okay, you get the instruction. I don't know if the particular instruction that's supposedly at issue here, which is the CJI instruction, really helps defendants all that much, because it provides no guidance to juries about how to come to a determination of whether the cross-race effect had an impact in any particular case.
The defendant has reached a conclusion that, in this case, this defendant thought it would be useful and helpful.
I mean, obviously, he made a request for it for perhaps strategic reasons. And that's the other thing, that in many cases, the defense might just have the instruction, believing that's going to create a reasonable doubt, but knowing that if expert testimony is provided, that expert testimony is going to show that the cross-race effect really didn't have an impact because, and this is also
But you could put on that expert testimony, correct?
right. But why,
No,
why-
if
why-
we agreed with the, I'm just saying, if we agreed with the defendant here, you're not foreclosed from putting on
why-
testimony.
why are we being put in a position of having to put on an expert test?
I know, it's
expert
your
testimony
burden.
to correct an instruction that doesn't provide sufficient evidence. So let me give you an example. If I go to a doctor's office and I ask about the flu vaccine, and the doctor tells me, some people die from taking the flu vaccine, and that's all the information he gives me, what am I supposed to do?
Well, he doesn't have to tell you, however, that you're going to die from getting it, which is how I hear, to some extent, the people's position, that somehow there has to be proof that in this particular case, given this particular person's contacts with people with members of another race, is likely or presumed or somehow.
It's a matter of probabilities.
Well-
It's a matter of probabilities. And so if all you're telling me, some people die from getting a vaccine.
Well, you understand, our purpose here is to reduce the probability.
And
You understand.
And I want to give.
So take the vaccine is what I'm telling you, Mr. Lieberman. You know?
Right, but that's what you're talking about, the decision maker. What knowledge does the decision maker need to make an informed decision? This instruction doesn't do the job. We want.
So let me ask you this. Are you opposed to any instruction, or are you opposed to this particular instruction?
We're opposed to any instruction because there's going to be problems with any instruction.
All right.
And can I just go?
Sure, go ahead.
Give the reasons
Go
for that? You can't fashion an instruction that's going to be, it's going to address the particular facts of the case, because all those particular facts are
I
different.
I get those
You
points.
can't come up with an instruction that's going to provide all the relevant information in any particular
Do
case.
we ever require that of an
Excuse me?
Do we ever require that of an instruction?
No, but we're talking about scientific knowledge. What instruction?
But isn't,
What-
how about our general instruction on identification, on eyewitness identification?
Right.
Isn't that, if we go back some years, wasn't that new science at some point?
No, lighting, look at the factors. Lighting, distance,
No, but-
we all have that experience. That's
No,
in our
But
human
the
nature.
fact that, because I think there was a belief, and may still be a belief, that eyewitness identification is extremely persuasive. That if somebody says with a lot of confidence that this is what I saw, and I'm sure it was him,
Okay,
and so our
understand.
instruction
Okay.
says that may not be the case.
okay. But we're talking about a general problem about how people assess eyewitness identification. And then the question is, how do we best serve the jurors?
But do we talk about the probabilities of how dark was it, and is 1 minute of viewing the defendant enough, or is 5 minutes
Well,
viewing the defendant enough? I mean, it seems to me that we're sort of getting into the weeds here, and we don't do that with other
We-
issues.
Okay, all of us have enough experience on a day-to-day basis to have some better understanding of how lighting affects our ability to perceive, how the amount of time has the ability to affect our ability to remember. But the cross-race effect is an entirely different beast, okay? There's a matter of social exposure. That has nothing to do with lighting. That has nothing to do with the amount of time that's passed. It's a matter of categorization. If you believe X, so somebody's of a particular race as opposed to another race, that could change your ability to make a subsequent identification merely on your conclusion about what race that person may be. That's the science. Also, there's the whole issue of that the cross-race effect can simply disappear if you have a sufficiently extended period of time to perceive the person, and if the time between the initial viewing and the identification procedure is not that great.
But see, the
this
problem,
isn't
in
a
part, but
problem-
may I say, in part, what I'm seeing as a problem with this, part of this argument is you're saying, don't give the instruction because the science is so complex. And the science is so complex because science tells us the science is so complex.
That's not
And
the
I'm,
case at all.
so then I've misunderstood your argument, because I thought your point
have-
was that it's not a common understanding, that it's really difficult
Well,
to
it is.
appreciate
It
this.
is, but the science isn't, scientists are saying it's a complex phenomenon. If you look at those individual studies, you see those complications. And
Well, what's complex apparently is the reason for it. There's a consensus that this is what occurs,
but the reason-
that it is
but
difficult.
the reasons
Not impossible,
but-
but difficult.
the reasons themselves have something to do with the evaluation of whether the cross-race effect plays a particular role. So, for example, the contact is one of the reasons why there is cross-race effect. But the jury knows nothing about that. And again, the devil is in the details. And you don't want you want your children to be educated by people who understand science if they're learning science. You don't want them to be educated by a committee of lawyers who come up with a sentence and then come up with language that hasn't even been vetted by an expert scientist. This is so important because we want to get it right. Let's stop just trying to get the quick fix. Let's let experts educate juries about a complicated phenomenon so they can make the right decision.
Thank you, Mr. Lieberman. Ms. Hull?
The New York State Task Force, which actually drafted the instruction that was ultimately slightly adapted by the CGI, did not do a simplistic instruction, and they consulted with experts. This wasn't a panel of lawyers who acted in a vacuum.
Counsel, there's not a lot of time, but under your rule, the Massachusetts rule, I'm trying to understand what discretion would be left with the trial judge. So in a given case where the defense lawyer asks for cross-racial identification charge, and the judge says, you're talking about your ex-spouse, I'm not giving it.
That's not a stranger identification. I think that's what distinguishes it. This would
Okay,
apply.
kidnapped 2 days.
Sorry?
Person is kidnapped but spends 2 days with the kidnapper.
Right. I think that type of error would be subject to harmless error, because even if I argue that
But then
that.
aren't you doing harmless error in lieu of discretion? Because what you're really saying in a harmless error analysis then is the judge had discretion not to give this.
Okay, let me ask, can I just take the analogy and try and answer it differently then? Okay, you've got somebody who was exposed to their kidnapper for 2 days. And so definitely duration is something that's an overriding factor. So even if the court should, and we want to make it a standard policy that courts instruct juries about this critical factor, that you have amicus writing you saying in one voice that it should be instructed on, ultimately, in that case, it's just not going to matter as much because you're not going to have.
But one of the amicus says it wouldn't apply to confirmatory IDs.
Right. So that's a different, again, that's a circumstance where you're looking at less, like you're not dealing with a stranger ID, which is where the real risk of misidentification exists.
But under our extended eyewitness ID instruction in our case law, we've said it's discretionary, and you look at all the factors. You look at, what there was to corroborate the identification. You look at the circumstances of the identification and all of these things. Why isn't that equally as appropriate in the context of cross-racial identification?
Well, I'm going to I'm going to just quickly note that even under a discretionary standard, our argument is that this case should still be reversed because you don't have those corroborating factors, and you don't have, because each conviction rests on a single cross-racial identification. But the expanded identification charge for when there is corroboration, there's two. There's one for, sorry, you guys know exactly what I'm talking about. But there's a second one where there's corroborating evidence, and this is included in that charge too. So our position is it's still important to include that. And corroboration is really a factor that bears on the admission of expert testimony rather than whether or not you still want to make sure the jury is thinking about identification, because even when you have something that may corroborate the identification so to not require the added process of having an expert, it may still be something the jury should take into account when they're deciding how much weight to afford that corroboration. The other thing that I want to mention is actually sorry.
No, I just have one question, follow-up on your, as applied to this case, abuse of discretion standard. Should it make a difference, the presentation that the defense counsel made here, which was, there's really no indication that any charge was ever provided, and then after the break, there is this, do you have any further, support for your position? No, and now we see studies and all this, volumes of support for the position. I mean, really, the judge at the time is making the decision and you exercising that judge's discretion based on the presentation made by that defense counsel.
Well, I would say that all of that support and all of the information that you've been provided was basically the exact same information that led to the creation of the charge in the first place. So that's why counsel doesn't have to specifically marshal that. And this issue is preserved if that's part of the question, because in terms of asking for a charge, this court's case law is quite clear in that regard. And there was no, when he was asked, do you have any additional case law to provide? He didn't, because none exists. That's why I'm here. And part of the reason why the amicus is helpful, I think, in this case, because it reiterates what not only the Massachusetts Supreme Court has looked at, the New Jersey Supreme Court has looked at, but frankly also what the New York State Task Force looked at, I believe, in drafting this charge. So that has actually been part of the process already. And the court's failure to give the charge because there was no expert testimony or he didn't think there was a sufficient record, that's undermined by the language that's in the recommendation for by the New York State Task Force, which says give this regardless of whether an expert testifies. And I'm here to tell you, let experts testify. I'm all in favor of that, but I don't think that we need to require and condition a defendant's ability to have a jury be educated on such a critical component when there is no dispute as to the effect. And that's really where...
Well, let's say we agree with you.
Okay.
We agree with you, and we agree also, and I see you smiling happy
Well,
about that.
sorry.
But let's say we agree with you. Let's say we even adopt the Massachusetts rule. Let's say we even agree, of course, that it's up to the parties and the judge whether or not a request to have expert testimony from the defendant is allowed up. If counsel decides not to call an expert, is that going to be ineffective assistance? Are we going to see the 440-10 saying you should have called the expert? Even though I got the charge, I still needed the expert for all the reasons the ADA has argued today. The jury still could not understand this, and you undermine my defense by not calling the expert.
No, because oftentimes there could be a strategic reason not to call an expert, or an expert wouldn't have met the threshold under this court's precedent under corroboration.
Can I ask the same question I asked your adversary? In this particular case, do you think that the trial judge was actually exercising discretion, or do you think that the record indicates that that the charge was denied because there was no expert testimony?
I think the latter, Your Honor. I don't think the court was exercising discretion. I think the court was simply saying just the fact that there's a cross-racial identification isn't enough here. And our position is, no, it is, especially when there's no other evidence supporting the convictions in this case.
Thank you, Ms. Hull.
Thank you very much.